You know, when you think about a $1 billion fraud case, you usually picture the smoking gun being what? A secret wiretap.
Or maybe a nervous accountant who finally flips. That's the classic.
Exactly. But in the case we're diving into today, United States v. Heppner, the star witness for the prosecution, isn't even human.
No, it's the AI chatbot. He was asking for legal advice on how to stay out of prison.
It's a truly wild 21st century twist, and we're really focused on this breaking development, a ruling from Judge Rakoff in New York from just this February 2026.
And it sets a massive precedent. It basically says what you type into a chatbot can, and yes, it will be used against you in a court of law.
It's huge. So to get the full picture, we've got the DOJ indictment, a really sharp client alert from Parker Poe, a tech analysis from Zatica, and a great legal breakdown from David Boies and Plimpton.
But before we even get to the AI, we have to talk about the fraud itself. The numbers are just staggering.
They really are. The main figure is Bradley Heppner, the former chairman of GWG Holdings.
Right. And the scheme itself, it's almost old-fashioned. Heppner allegedly used a shell company he secretly controlled to siphon, what, over $150 million from his own company.
And the way he did it was so brazen. The indictment from 2025 lays it all out. He used this shell company, HCLP, and told his board it was just some independent third-party lender.
When in reality, he owned it. He was on both sides of the deal.
He was effectively loaning the company's money to himself and then lying about it to auditors, to a special committee, you name it.
And the fallout was catastrophic.
Yeah.
GWG filed for bankruptcy.
And the bondholders were left holding the bag for more than $1 billion in losses.
So you've got Heppner, the feds are closing in, and this is where the story pivots. Instead of just sticking with his lawyers.
He starts kind of freelancing his defense strategy.
Yeah, using Claude, the AI tool from Anthropic. He generated around 31 different documents, brainstorming all these potential legal arguments.
He's basically treating the AI like a junior associate, right? But then the FBI raids his mansion.
They seize all his electronics, and of course they find these chat logs.
And his lawyers immediately try to get them thrown out. They argue attorney-client privilege or the work product doctrine.
Which, on the surface seems like a logical move. He was preparing for his defense.
Exactly. Why is talking to an AI any different than writing a private diary entry about your case?
Well, that's the question Judge Rakoff had to answer. And his ruling was incredibly blunt. He said it's not privileged because there was no confidentiality.
How is there no confidentiality? It feels like a private conversation.
It feels like it, but it isn't. When you use a commercial AI, you agree to its terms of service. And Anthropic's terms say they can view your inputs. They can even share them with regulators.
So you've already disclosed it to a third party the second you hit enter.
The privilege is gone. Legally, it's like discussing your case with a friend in a cafe, not your lawyer in a sealed office. The confidentiality is broken.
Okay, but what about the other argument? The work product doctrine. This is something the Parker Poe brief got into that I found fascinating.
Right, so that doctrine protects materials prepared for litigation. Heppner was definitely doing that.
So why did it fail?
Because that protection usually only applies to work done at the direction of your counsel.
And Heppner just went rogue.
He did it all on his own initiative. His lawyers didn't tell him, go use this public AI tool. By doing that, he waived the protection. He basically created a roadmap for the prosecution.
So he used the AI to try and beat the fraud charge, and that very act became the proof of his intent. It's an incredible catch-22.
It really is. It shows this huge gap between how we feel about AI and how the law actually sees it.
So the big takeaway for you listening is pretty clear. Unless you're on a specific enterprise plan that guarantees confidentiality.
You have to assume the chatbot is a snitch.
It does make you wonder about the future, though. We know big law firms are adopting these enterprise AI tools that do come with those guarantees.
That's the next legal battlefield.
Yeah.
If Heppner had been using a paid, secure version of Claude, would this ruling have been different?
Yeah. Does legal privilege require a human pulse? Or is a really, really good contract with an AI company enough?
Something to think about.
Definitely. Thanks for joining us for this deep dive.